This presentation focuses on the use of the significant harm checklist in the risk model. My name is Bruce Thornton. I'm a trainer and consultant and worked with Dafydd Paul of Gwynedd Council in originally developing the risk model. It is sometimes referred to as the Gwynedd risk model and sometimes as the Bruce Thornton risk model. This presentation is part of training and development resources developed by Gwynedd Council's Effective Child Protection Project. That model has 4 components, one of which is focused on threshold. So this presentation fits within the threshold component of effective child protection. The risk model was developed in order to ensure that child protection practitioners were able to make good and consistent decisions in relation to significant harm. Reducing variation in practice, reducing inconsistency is a key to driving up practice. As we work through the significant harm checklist, we will refer to the underpinning law and case law that helps us clarify the question of defining significant harm. In addition to the checklist, there is also further guidance available. The question of significant harm is fundamental to child protection practice, and there are many other supporting documents and videos in the threshold section of the Effective Child Protection Practice resources. This section explains the significant harm checklist, what it does and where it fits in the various processes. We developed the significant harm checklist originally to help practitioners complete Section 7 in Risk 2. This section records the aspects that may make harm significant. Stage 2 risk assessment, or Risk 2 as it is often called, was developed as part of the risk model. It was a 2-stage model to assist in the identification and assessment of significant harm in children's social care. Stage 2, or Risk Stage 2, is a comprehensive assessment. It included a focus on the child's needs, parental capacity, whether there was harm, its likelihood, and whether it was significant. The significant harm checklist is focused only on significant harm and therefore has a different focus to Risk 2. It was originally developed for practitioners who found it challenging to identify the factors that indicated the significance of harm in some cases. It proved a successful addition to the Risk 2 assessment, but over time it has also established its own credibility as a standalone assessment of significant harm. Some authorities use it as part of Section 47 inquiries and case conference reports. Its focus is narrower than Risk 2 and is sometimes used separately to the Risk 2 assessments, in many ways being more focused and having less aspects to consider saves practitioners time and can be used as a quick reference to support decision making. So, what is it? It can be described, as we would with Risk 2, as a risk assessment. Of course, this assesses specifically the risk of likelihood of significant harm. This is, of course, the key decision in children's social care and child protection work. It establishes whether we have a duty or not to intervene statutorily. That means that is the decision that either forces us to take child protection actions or otherwise confirms we actually don't have the authority to do that. The question of whether the evidence is indicative of significant harm is a complex set of considerations. So this was developed to bring together the information that practitioners needed in order to make decisions, specifically about significant harm. So it is an analysis framework to understand the issues related to significant harm. It drives consistent decision making. It's based on law and case law judgments to identify the areas to be considered, bringing these together into a form or template. The significant harm checklist, similarly to the Risk 2, very much echoes Professor Munro's recommendations in the final report to the baby Peter case. The Munro report focused on social work decision making. Workers should be judged not by the outcomes of their decisions but by the consistency and quality of decision making. So Risk 2 is driving at making consistent and good quality decisions. So what does the significant harm checklist do? We've already mentioned its use as a way of getting at consistent and good quality decisions. This assessment establishes the most important decision in child protection. It determines whether the state can or cannot interfere in the private lives of families. This question of significant harm is what gives us a duty to intervene. Think of it as a switch. If you have likelihood of significant harm, you have a lot of authority to act or protect children from harm, abuse or neglect. You do this regardless of the cooperation of families. It's a very invasive power that the state has in people's lives. And of course, If the switch is positioned the other way, you have no likelihood of significant harm, then you can't intervene without a family's consent. I want you to think a little about the power we have in people's lives. Terrorism law gives similar power, but not much else gives the state such powers to encroach on people and families' privacy. So this decision is very much about protecting human rights and determining whether a family's right to privacy or a child's right to be protected is most important. I want you to think of this decision about significant harm taking place continuously. Similar to RIS2, the checklist can be used formally and informally. Informally as a quick reference or aide-memoire, more formally as evidence at the end of a Section 47 inquiry, where the determination about significant harm is important to determine the threshold to proceed to initial child protection case conference. The key legal phrases, words and concepts used, including harm, significant harm, substantiality, meaning and likelihood. In law and case law, there are a number of terms you need to understand. First, we focus on what indicates that harm is caused to the child. Secondly, we consider whether that harm, if it exists, is significant or not. Some situations will indicate harm, but this harm is not significant. Lastly, we look at prediction or likelihood of significant harm occurring. The first legal component is harm. There are two elements to the definition of harm. Ill treatment, which is abuse, and impairment, which is the impact of a child's needs being unmet. Since the Adoption Act, the impact of seeing another person abused, as in the area of domestic abuse, is also included as an impairment. Most, if not all, children will have some needs that are not met. The question for Children's Service is whether an unmet need or needs result in ill treatment or impairment. Of these two aspects of harm, I think it is ill treatment that is easiest to define. Ill treatment means harm or abuse. Impairment, on the other hand, is more complex. It is the effect that the failure to meet the child's needs can have, and this can be in any of their needs. The development of their health or meeting their emotional needs, or their need for basic care and stability. The Assessment Framework Triangle presents these across 3 domains and several dimensions. Added to the definition in the Adoption Act is witnessing the ill treatment of others. The emotional impact of seeing abuse, for example, the impact of domestic abuse on children and young people. The second legal component is significance. If we look at the legal definition of significant harm, Section 31 of the Children Act states that you should compare the child's health or development with a similar child and ask, is this what would be reasonably expected? Whether the phrase reasonably be expected helps us in differentiating harm from significant harm is a matter of opinion. It does not seem to me to clearly define what makes something different. If we look at the often quoted statement from Working Together 2010, it tells us there is no absolute criteria to rely on, so a little like the young girl's expression, where does that all leave us? However, Working Together goes on to give us one of the most quoted paragraphs in relation to significance, which has in fact been the basis of the first section of the significant harm checklist. It introduces the idea that you should evaluate the severity of any harm or abuse against how it has affected the child, how they perceive the abuse, and how long it is going to take to overcome the impact of the harm. So seriousness isn't absolute. Seriousness is in the context of the child's circumstances, their response and resilience. And of course, significance may be indicated by a single event of abuse or otherwise seemingly lower level of abuse, but its impact over an extended period of time. The statement from Working Together introduced explanatory statements that may be associated with significance. For example, the degree and extent of physical harm, duration and frequency of neglect, extent of premeditation, presence of threats, coercion, sadism, or bizarre events. We'll come back to this again later. When lawyers are unsure of a word and that word isn't defined, they turn to the dictionary. There was a court case in Cambuside County Court where a dictionary definition was used to illuminate the interpretation of significance. The dictionary definitions included having or conveying a meaning, full of meaning, highly expressive or suggestive, important, notable, and in another, the primary sense of significance is conveying a meaning or suggesting an inference. Section 1 of the Significant Harm Checklist identifies substantiality of harm, and Section 2 explores meaning or inference. Case law expands on our understanding of the significance of harm. It uses common language to define it as something important, noteworthy, or considerable. Other case law reminds us that significant harm is not usual, it is something unusual, and for that threshold to be met, a child has to be positively harmed by the failure of family life. That's where the threshold is pitched in law. The way case law illuminates the question of significant harm helps us understand the way the law is interpreted. It helps us become clearer about how we interpret the information and which elements are relevant to consider. So, 2 elements. Firstly, from working together, substantiality of harm, and secondly, from case law, significant harm has meaning, inference, or attribution. The third phrase is likelihood. What is important to remember is that in all considerations we aren't just addressing the current circumstances or evidence to identify significant harm, we are also considering whether harm is likely to become significant in the future. For example, the local authority's duty to investigate is where a local authority has reasonable cause to suspect that a child in their area is suffering or is likely to suffer significant harm. Then the local authority should make inquiries to safeguard and promote the child's welfare. And of course, when looking at prediction, often lower levels of harm over the longer term, when regular and frequent, may become significant if it continues unchecked, despite the fact it may not be significant harm now. Case law illuminates the question of likelihood as well. The court held that a likelihood of significant harm under Section 31 of the 1989 Act means no more than a real possibility that it will occur, but a conclusion to that effect must be based upon a fact or facts established on the balance of probabilities. So, a real possibility that it will occur based on facts and evidence established on the balance of probabilities. Some case law suggests that if the question is about likelihood of in the future, it is something feared rather than something established in fact. It also suggests the importance of how likely and how severe. To satisfy the threshold, the severity of the harm is inversely correlated with the likelihood. So, if it's less likely the harm is to occur, then the actual harm would need to be more serious to meet the threshold, and the other way. If it is very likely to occur, then the harm feared can be less serious. We're also asked to consider the question of likelihood based on something having actually happened in the past, that there is evidence that this did actually happen. However, if the question of likelihood is prediction of future harm without past evidence of harm, the court only needs to be satisfied that there is a real possibility, a possibility that cannot sensibly be ignored, having regard to the nature and gravity of the feared harm in this particular case. So you couldn't sensibly ignore it, given how serious what you fear would be if it happened. Using the checklist takes you step by step through the form, explaining how do you use and complete the significant harm checklist. If we focus specifically on the format of significant harm checklist, its sections and how to complete it. I just wanted to remind you that there is a significant harm checklist guidance document that is also available. It has 2 main sections. Section 1 looks at substantiality of harm, and Section 2 explores meaning to the harm. Section 5 has a good practice check against 3 factors. This ensures that you have enough evidence to make effective assessment and analysis of information. Significance includes 2 components, substantiality and meaning. This section focuses on substantiality. The significant harm checklist was developed from guidance and case law, which indicated the question of significance included two elements. These are substantiality and meaning. Section 1 focuses on the question of substantiality, severity or seriousness of harm. It is designed around the elements identified in paragraph 1.28 of Working Together, 2010, that often quoted reference to what makes harm significant. In the statement, it links indications of severity, acknowledging that some types of events are more difficult for children to overcome and recover. Hence, the impact of the harm is more enduring. This is the paragraph from Working Together, 2010. You'll note the examples of what makes harm significant and include degree of harm, its extent, duration, frequency, if it's premeditated, if there was a degree of threat or coercion, or sadism, or so on. These are listed as they have been associated with types of experiences that children have great difficulty overcoming in their lives. As a checklist, it helps you review your case and what in particular about those circumstances, events or behaviours indicate that the harm is severe. It concludes with a professional judgment statement whether harm is substantial or likely to become so in the future. Significance involves two components, substantiality and meaning. This section focuses on meaning and its three subsections: reasonable parent, beyond parental control, and grooming and exploitation. Section 2 is based on a situation that lawyers, when faced with needing to define a word that is not statutorily defined, refer to dictionaries. The word significance is associated with conveying a meaning, suggesting an inference. I think this indicates there is something additional meant by this. It means more than the value of the word itself. There is something under the surface. We referred earlier to case law that indicated that the significance was something important, noteworthy or considerable. There is case law derived from the dictionary definition being used as a test of significance in court cases. We explore meaning by asking questions in three domains. These are reasonable parent, whether the child is beyond parental control, and whether there are external factors present. These three perspectives are included to assist your explanation of various factors that may indicate significance. However, they are prompts. They do not provide the answer. As you appreciate, professional judgments are inherently subjective, based on applying practice experience to gathered evidence. We try to make it as objective as possible by providing structure and formats. Firstly, we ask ourselves whether what we're observing about parenting here is what would be expected of a reasonable parent. There are a series of prompts to elicit information about this. It seeks to test our perception of reasonableness of the actions or response. The what is out of the ordinary test. We ask, what would a reasonable parent have done in the circumstances? What is out of the ordinary about what's happened? What is the parent doing or not doing that worries you? Is it likely to occur in the future? Was it an act of omission or of commission? Each section finishes with a professional judgment conclusion. Is the harm attributable to care given or likely to be given, not what it would be reasonable to expect a parent? This is directly related to the underpinning law. In this case, Section 31(2)(b)(1) of the Children Act 1989. The second section in meaning again refers to Section 31 of the Children Act 1989 and the grounds or threshold for certain orders made by the court. This is a different test to the reasonable parent test, but is whether the child is beyond the control of parents. These are a series of prompts to elicit information about the area of being beyond parental control. Firstly, an objective account of what takes place, and then separately, what is it about this that worries you? We sometimes find supporting parents who try everything, yet find it difficult to influence the child. And in contrast, children beyond parental control and that lack of control indicating neglect and poor supervision by the parents. Those are very different scenarios. The section finishes with a professional judgment conclusion. Is the harm attributable to the fact that the child is currently beyond parental control or likely to be in the future? It is again directly related to the underpinning law in this case Section 31, brackets 2, brackets B, brackets 2 of the Children Act 1989. The third section in meaning refers to more modern factors that weren't as prevalent in 1989. This is the area of grooming and exploitation. The harm may not be a failure of a reasonable parent or that of a child being beyond parental control, but that other forces were at work, such as sexual or criminal exploitation. Section 2.3 includes 2 prompts to explore the issues relating to exploitation. Firstly, an objective account of what takes place, titled "Please describe the circumstances," followed by "What is it about that worries you?" It asks, explain your concerns about the behaviour and its consequences. The second section explores the likelihood that it will occur in the future. The section finishes with a professional judgment conclusion. Is the harm attributable to other factors other than those already considered, such as parental capacity or the child being beyond parental control? Next, we look at Section 2 in totality. It concludes with a professional judgment statement, whether there is additional meaning, attribution or inference to the harm that may make the harm significant for the child. This is drawn by reference to the relevant sections 2.1 reasonable parent, 2.2 a child beyond parental control, and 2.3 a child under the influence of external factors such as grooming, criminal or sexual exploitation. The decision support tool section helps bring the conclusions together to drive decision making. Section 3 brings the elements together from harm in risk 2 to the question of severity now in the future and meaning now or in the future. If all of these are evidence and checked, there may be an indication of significant harm now or in the future. Harm is either established in risk 2 or evidenced in the checklist. Factors indicating severe or substantial harm indicate harm firstly and then its quality as being severe or substantial. The question of substantiality is evidenced and considered in Section 1 of the checklist. Is this harm substantial now or likely to be in the future? The question of meaning is evidenced by Section 2 of the checklist, again either currently or likely in the future. The decision-making tool prompts evidence from each section. If you have a positive finding of harm, which is substantial and has meaning, it indicates significance now or in the future. If you remain uncertain about whether the overall threshold is pitched correctly, Section 5 has 3 sets of good practice pointers for you to consider. The Section 3 decision-making tool draws together the various findings into an overall conclusion. This is recorded here. The question is, based on the evidence gathered and analysed so far, is there an indication of the likelihood of significant harm now or in the future? Yes or no? Summary statement and decision section include information about how to write the summary statement and recording your decision. Section 4 has 2 elements. Firstly, it provides somewhere to record your analysis. Analysis is about answering a question. So here we are answering the question about the likelihood of significant harm. And this is the rationalisation and interpretation of the information collated. It is similar to the reason of a decision statement in risk 2. Secondly, you record the final decision about significant harm currently or likelihood in the future. And then, if you have identified significant harm, whether it is likely to continue in the future. The summary statement brings information together. There's a lot of information about this in the guidance document. The summary statement is drawn from sections 1 and 2 of the checklist. Section 1 focuses on the question of substantiality, linked to the indicators from Working Together 2010. Section 2 focused on identifying meaning or attribution. Section 2 has 3 elements: reasonable parenting, a child being beyond parental control, and exploitation. In the guidance documents there are several examples. If we look at an example of a summary statement, this spreads over 2 sides. This is an example only to give you an idea of how these are constructed. This would be an example where the significant harm checklist has been used with the risk 2 form. As you read this, you may be able to identify on which sections of the risk 2 and checklist these statements are based. So, if we read this as a whole, we'll see reference to harm, parental capacity and child's needs. It starts saying strong indication of harm, a component in risk 2. The second part focuses on substantiality. The first paragraph is based on risk 2, strong indication of harm derived from limited parental capacity and many unmet needs. We also see here a critical need unmet. Each of these statements is qualified with an example. It meets the good practice check from section 5 as it links the harm with the parental behaviour assessed. Poor supervision and lack of safety regarding exposed sharps and unknown adults linked to the parent's substance misuse. The second paragraph is based on the significant harm checklist. It describes the harm as neglect and explains what aspects of neglect have been identified: lack of food, poor home conditions, safety issues. It then identifies from section 1 the indicators of substantiality, series of events, frequency of harm, extended period of harm and the likelihood to continue. If we looked at an example of a summary statement, this is the second of the 2 slides. If we look first at this in totality before focusing on the components. Here we see reference to meaning or attribution. It classifies as a mission or commission, explaining why this is not the behaviour of a reasonable parent, illustrates the parent's response to intervention and failure to sustain change. It again links to the section 5 good practice checks, the failure of family life. It draws this together, substantiality and meaning, clarifying the decision and placing the decision again against a section 5 good practice check, namely that you have sufficient information at a point in process to make a decision. This first section is specifically about meaning. It links clearly to the fact the meaning in the example is about reasonable parenting, as opposed to other types of meaning, such as beyond parental control or exploitation. It locates this as an act of omission, a failure to do something they should have done. It provides a qualifying statement of the evidence why this was a failure to act as a reasonable parent. Here are unknown, potentially unsafe adults in the home posing a risk to the child, inferring a lack of parental supervision and protection, placing their own needs above the child. The second example of exposed hypodermic needles is a life or limb threat to a mobile child's safety. These are indicative of a critical need. The meaning is in respect of the parent's neglect and the serious possible life or limb consequences of that failure. The second section is also about meaning. Section 2D looks at what would happen in the future, and this statement refers to the responses of the parent. This statement alludes to the possibility of disguised compliance, but is not explicit. It is clear that this is predicted to continue. The last highlighted section here links to the section 5 good practice check, testing whether the threshold is actually identifying harm caused by a failure of family life. This is a statement derived from case law and the comments of the Right Honourable Lord Justice McFarland. It states that with the evidence gathered in relation to substantiality and meaning, the assessment concludes with a decision that there is an indication of significant harm. This example also gives reference to which process this assessment supported, namely the end of a Section 47 inquiry and a decision to proceed to an initial child protection conference. The summary statement therefore blends the evidence from the various sections in Risk 2, sections 1 or 2 of the significant harm checklist. In this example, we see blended the social worker's awareness of neglect, cycles of change, and disguised compliance. This has some structure to it, but it's very much about the practitioner bringing together the relevant features to support the decisions made. The decision box finalises decision about significant harm, current or likely, in the future, and the prospects for this to continue. Good practice pointers are created from the 3 key messages from practice and case law. Section 5 of the form includes 3 checks based on case law. The significant harm checklist has an explanation of each of these in more detail. Firstly, do you have enough strength of evidence or information to make a decision now? Sometimes you need to wait for more information or seek more evidence. At other times, there is no time to gather more information. So this is a check. Do I have enough or not? It questions the proportionality of what you've done so far and what do you know. Do you have grounds to seek further information? Do you have time to make further inquiries? As you appreciate, you will never know everything or be sure of everything. So this is a check for you to question. Can I make a decision now? Do I need to make a decision now? Is my position strong enough? Proportionally to the time available and the risk of further delay. Secondly, a point based on case law. If you are drawing conclusions about causality of abuse with parental behaviour, make clear you establish the evidence to support this causality. It is too easy to find and list parental deficiencies and find unmet needs and harm caused to a child. It is the linkages that are important to establish and provide supporting evidence for this. It's not good enough to list the shortcomings or deficiency of a parent and then make an observation about general harm and allow the reader to make inferences. If there is evidence of factors related to the behaviour of parents, and if these have relevance to a conclusion of significant harm, it should be explained how these things relate to each other. So, if parental mental health, domestic violence and substance misuse are present, and if the conclusion is related to emotional harm and neglect, and if you are analysing one thing caused the other, you must make this clear and explain the evidence that leads you to this conclusion. Otherwise, generalisations can be made of parental attributes about harm without an explicit connection being established, and parents will not have the opportunity to defend their behaviour. Thirdly, case law indicates that the threshold is the child is positively harmed, that something actually dynamically happens to them to cause harm as a direct consequence of a failure of the family to meet their needs or protect them. It is something more than commonplace human failure or inadequacy. This is based on the observations of the Right Honourable Lord Justice Macfarlane, who said that the state should not intervene unless there is evidence that the child is being or is likely to be positively harmed because of a failure of family life. The checks on Section 5 are recorded by answering a yes or no in each statement. The section includes an explanation of the good practice prompt or the case law that underpins this. The aim of such a check is to prompt the practitioner to reflect on their practice. It may serve to reassure, or alternatively, it may prompt the practitioner to clarify or improve their summary statement and decision. Testing your judgment focuses on ways to test what you've learned. Sometimes reversing the question may help. Instead of looking for evidence that is significant, what tells you it isn't significant harm? And we use a quick quiz format as a revision of some of the things we've looked at. We've focused during this assessment on what can be termed a positive or progressive analysis. You are continuously prompted to check specific features or aspects and confirm whether they're indicated. You're looking for something and seeing if it's there. If so, you tick that off and may feel confident in your assessment. Examples of this are those questions. Is the harm extensive? Was it premeditated? Is it an act of omission or commission? Was this reasonable for a parent? Is this likely to happen again? Some practitioners find it useful to also work backwards. What tells you that something isn't significant harm? We know if there is no harm, despite concerns about the parents, which may leave you believing there is some meaning to their behaviour, in the absence of harm or likelihood of harm, there can be no significance. That is why establishing harm is the first step, often well supported by the use of risk 2. We also know if the harm isn't substantial, if the harm has no meaning, if the harm is just human failure, inadequacy, all of these would suggest you haven't got threshold. And if you have parental problems, and if you have unmet needs of a child, that you cannot clearly connect these together, it again suggests you aren't identifying harm which is significant. We can put this to a test. This is a quick quiz to test people's ability to make decisions about significant harm. What it shows is that with very limited information, you can identify whether something may indicate significant harm or not. Of course, you may say, I need more information, but often, in duty terms, this is the crux of basic information you receive. You have to make decisions. Ask proportionally. Do I have the duty to make further inquiries on the basis of this? Look at these 3 case examples. That's all the information you have. The decision will be based on the balance of probability. Baby with broken ribs, only been in the care of its parents. What do you think? Is the harm substantial or serious? Is there meaning? Is it significant harm or likely to become significant harm? A baby cannot inflict these injuries themselves, so a fracture to the ribs is substantial, it is serious harm, so yes. So is there meaning? Well, parents are the only caregivers, probably inflicted or as a result of neglect, so yes. Significant? Yes. So if this came in as a report or referral, you'd have enough concerns about likelihood of significant harm to move into the first steps of child protection, initiating a strategy discussion with the police. Teenager sexually assaulted by strangers. What do you think? Is the harm substantial or serious? Is there meaning? Is it significant harm or likely to become significant? Teenager sexually assaulted by strangers. The sexual assault is substantial, seriously harmful, so yes. Is there meaning? Well, we don't know. We don't have enough information. Was this a random assault? Was what she was doing safe? Were the parents reasonable? Until we have more information, this could be substantial harm with no meaning, not significant harm, or otherwise. So we don't know enough yet to make this judgment. So we're not sure. In this actual case example, the parents knew where the girl was. She'd gone several times and it was considered safe. This was a random crime against a child. The parents had been reasonable and responded appropriately to their daughter's needs as a victim. So there was no significant harm. Of course, this did come in as a child protection referral. Agents wanted the victim to get help. However, the need was not one that could be best met by a child protection intervention. 8-month-old baby, carried in a baby carrier up Snowdon in February. Other walkers had tried to intervene on seeing the baby, telling parents the baby was cold. Parents continued with their climb. Mountain rescue had to be called in finally, and the child was rescued. What do you think? Is the harm substantial or serious? Is there meaning? Is it significant harm or likely to become significant? Hypothermia is a medical crisis, a threat to life for a baby. So yes, it is substantial harm. Is there meaning? Yes, a failure of family life to protect the child, not a reasonable parent decision. Unwillingness to heed the concerns of passers-by. An act of commission or omission? Probably omission. There was no intent to cause harm. Significant harm? Yes. Likely to happen again? No. This is a real historical case that was in the press. Newspapers reported the parents were of good social standing. If this came in as a report or referral, it may require a Section 47 inquiry to establish facts, and yes, significant harm would be evidenced. However, it is unlikely to happen again and was, despite the seriousness of their error, an exceptional situation. This does provide us with influences to consider the influence of preconceived assumptions about people and how this influences our judgment. So, 3 questions, and it was possible to quickly make decisions about significant harm, and in one case, why we needed more information and what type of questions we needed to ask. It illustrates the practical way that structure can support decision-making, making these better, more consistent, leading to practitioners who have greater confidence in their ability to make decisions in some of the most challenging areas of social work and child protection practice. The Reviewing Terms section reviews the terms, concepts and words used. This subject includes many words and concepts. Some have definitions while others are poorly defined, so this is a recap. To help clarify, for some concepts, 2 or 3 words have been offered. These mean different things to different practitioners. Having 3 options may help interpretation. So, Substantiality can be explained with the words seriousness or severity of harm, and meaning can be understood by using the words attribution or inference of the harm. We use the word significant harm a lot, but sometimes people use substantial in the place of significant. So, to be clear, substantiality of harm is not the same as its significance. Substantiality is one of two components of significance. These are substantiality and meaning. When we talk about significance, it is not just past, present, it can also be the likelihood of significant harm in the future. First of the two components of significance is substantiality. From working together a list of indicators: intentional, bizarre, coercion, sadism, premeditation, extensiveness of harm, etc. The second of the two components of significance is meaning. The three main categories: what would a reasonable parent do? Is the child beyond parental control? Is the child groomed or exploited by external factors? Likelihood or prediction for the future. Likelihood is a real possibility. It will happen. Such is the fear of the consequences, it cannot sensibly be ignored. And we see in case law, if it's unlikely to happen, then the consequences, if it did, would have to be very, very serious to meet threshold. Whereas, if it was much more likely to happen, the seriousness could be less in order to qualify. And if you are predicting on the basis of something that has happened before, you need to be clear that you have evidence that what you are concerned about will repeat did actually happen. Whereas, if you are predicting about something you fear may happen, there has to be a real possibility it will happen. Significance of harm is legally defined as compared with that which would be reasonably expected of a similar child. Parenting is judged on a standard of what a reasonable parent would be. The standard of the development of a child is compared with what you would expect of a child like him or her. We also hear that significant harm is much more than something usual or normal. It is more than you'd get in human failure or inadequacy. It is considered noteworthy and important. Significance has two qualities. It is substantial harm and it has additional meaning. The reflection section introduces some prompts for reflective practice. As you reflect on your practice, ask yourself, do you think the significant harm checklist would be useful for you in your own practice? Do you understand what the checklist is and how it's used? Think about the difficulties you imagine in using it, and every time you do use it, how would you reflect? Would you know how well you'd used it? And of course the key issue is the question of significance. Are you clear what significance is? What information do you need to consider to establish it? As you develop your practice, remember that to learn, you do, and then actively reflect on what you've done. This can be done through self-reflection, with colleagues, and most importantly, in your supervision sessions. Thank you for listening. There is more information on other sections of the Effective Child Protection resources